Yeah, I think a lot of us, when anytime our mom or our dad has to be in the hospital, they're sick for any reason, we worry about things like, do I need a medical power of attorney or anything else?
And I might think, oh, I have a power of attorney, not necessarily realizing that that might be the durable one and not the medical one. So today we have Jeff Barnett and Keith Ludy from Barnett and Ludy Law Firm with us to help us understand kind of the distinction, because I think that there is confusion sometimes thinking I have a power of attorney, not necessarily realizing that it's so important to have both. And today we're going to focus on the medical legal documents that we need, including the medical power of attorney. So talk about a little bit about what's different between the medical power of attorney and what that allows you to do.
All right. Well, a durable power of attorney, often called a financial power of attorney, or something like that. It is basic, or a general power of attorney. It basically covers all of the financial, property, legal, all of those types of things. And a medical power of attorney is basically only for medical needs. In fact, you could almost think of it in the reverse. The medical power of attorney is for medical needs only, and the general power of attorney is for basically everything else. So the medical power of attorney basically comes into play if somebody is incapacitated and unable to make medical decisions for themselves, unable to understand their situation and discuss it with their doctor. And so, if they need to have medical decisions made or consents signed, that kind of thing, that's where the medical power comes into play.
And the medical power of attorney is what we call a springing legal document, meaning it's inactive until a doctor makes a determination that their patient doesn't have the capacity to understand, the ramifications of medical decisions, and they flip that switch and basically turn it on by signing a physician's affidavit of some sort verifying that fact. Even before they do that, though, we found that for some doctors, every place is different. If a person is named as the future or presumptive medical power of attorney, that sometimes will bring extra comfort to the doctors when a person wants to bring a family member or friend or whatever into the consultation at an early stage, even when they can understand what's being discussed. Because if that person were to, especially if they have a cognitive decline issue, they don't want the new medical power of attorney to have to be brought up to speed if they could be along for the ride the entire way.
Right. And that was actually kind of the question I was going to ask was, when I think sometimes we think of incapacitation, a lot of times we think of maybe a coma or something where they're not responsive, but it also comes into play with cognitive issues, dementia, Alzheimer's, things like that, right? But that is a little trickier. That's a little trickier, isn't it?
Sure. Yeah, absolutely. Yeah. Sometimes, as a result of a head trauma or some kind of situation like that, it can come on suddenly, but a lot of times it comes on gradually, like with dementia and Alzheimer's and situations like that.
And the really tricky situations are when you have somebody who has maybe sundowners, where in the morning after they've had, 3, 4, 10 cups of coffee, whatever it is, they are perfectly fine. But then as the day grows on, now they don't. And so, the doctor's not going to sign the affidavit, take it back, sign it, take it back. They're not going to do that. So it can get a little bit tricky.
Yeah.
Do you need a power of attorney to talk to a doctor, whether mom or dad is incapacitated or not, to talk to a doctor about what's wrong?
I think what you may be thinking of there is maybe a HIPAA release. As far as being able to to receive the medical information. Is that what you're? Yeah. So,
Well, I'm just thinking that if I'm worried about my parents,
I'm worried, yeah.
If I'm worried about my parent and maybe they're not telling me,
yeah,
they're not necessarily telling me what's going on, but I've got the medical power of attorney, and I feel like there's an issue, and I
need for you to tell me what's going on.
Sure. Yeah. So, the medical power of attorney, of course, is the document that allows the person with the person who is the agent under the power of attorney to make decisions for and consent for somebody's medical care. But and the HIPAA release that is a reference to the law that was passed years ago about portability of healthcare and whatnot. But it also a strong piece of that was the protection of information and of an individual's personal information. And so in order to receive information about somebody else, whether you're a company or an agent under a power of attorney, somebody has to consent to you receiving that information. And so a HIPAA release is basically a waiver of that privilege or a waiver of that protection as to this particular individual or entity. And so we definitely usually include a HIPAA release in a medical power of attorney, because making medical decisions for somebody without information to do so would be pretty difficult to do.
Yeah.
And there are people, attorneys out there who will do the HIPAA release separate. Not necessarily wrong. I think it's just a matter of preference.
Yeah.
We include it in the medical power of attorney because then you're not having to search for a separate document. I mean, it's all there together.
Yeah, because I think one of the questions that we hear discussions about a lot is the fact that mom and dad won't tell me what's going on. They think they're fine, and I know they're not. And I want to be able to talk to the doctor and give them a little more insight, perhaps before a doctor's appointment. Maybe they don't want me to come along. And if I have a power of attorney, am I still able to sort of find out that information? And I think what you're saying is probably not.
Not just the power of attorney, especially the springing type. And the medical one is always a springing type. The property and financial one, can be made immediate or can be made springing.
Do you have any suggestions on if you have a parent who is very private and doesn't want to, how do you have that conversation with your parent where you want to start getting more involved with their medical care or medical knowledge, what's kind of going on, and they really don't want to give you either medical power of attorney or that HIPAA release?
That's a tough question because it's so person specific, and we've come across people like that before where they say, dad just is real private about it. He wants to say that there's nothing wrong. And I guess the best advice that we can give is for some people, there may be people that they will open up to more than others. I know one case that we had in particular, the older parent, the dad was having prostate issues, and his daughter really, was saying, I don't think I want to talk to my dad about prostate issues. And probably it was a mutual thing, right? But there was a son involved, which maybe dad would open up to the son a little bit more about that. So you first have to find out, why are they private? Is it kind of specific to what they're facing, or is it just that they are a closed book entirely?
Yeah. And maybe what I'm thinking is that maybe if you can have it while everybody's healthy, so that it's just sort of a document that you have in place, where it's not actually it's not as immediate, it's not as in a crisis, where then maybe that would help.
You're kind of playing to their strengths, like we do with all
do it early on, and make it, just something that you say, I'm not, wanting to pry into your business right now. You're in control of all of that right now, but someday you might be, in a coma, or someday you might have dementia or a head injury, and I may need to have the information in order to make proper decisions for you. So so we need a HIPAA release just for that, and then you've got the document, and it can be used as needed.
And here's the big argument, because money talks, right? I tell people that if you have, and it's not just your medical, it's also that durable power of attorney. If you have those two in place and strong and have all the correct language in there, you're pretty much covered come what may. If you slip into a coma, you fall and hit your head, whatever else, you have designated your choice of who's going to be able to make those financial and medical decisions for you. If you don't have them in place, the legal recourse typically would be seeking guardianship. And once you start looking into how much guardianship costs and how many times people have to go to court and everything else, and compare it with the price of a medical power of attorney, it's a numbers game. And even stubborn people can understand that, because there's a vast difference between all of the trouble. You either have the road paved or you have a road full of potholes, and they have to understand that difference.
Yeah, figuring out
So-
what appeals to them.
That's right.
Yeah, what might get their attention.
So if mom and or dad have a medical power of attorney with the HIPAA release, what else would they need? What else do I need to make sure that I can take care of them or
Yeah.
do whatever is necessary for?
Yeah, I would say that they should also have a director to physicians. The big long name in the state of Texas is a director to physicians and family or surrogates, but the shortened name is director to physicians or physician's directive. It's also commonly referred to as a living will or an advance directive. A medical directive. It's basically the document that a lot of people think of as the pull the plug, under certain circumstances, and it only comes into play if you're incapacitated and can't speak for yourself, just like the medical power of attorney. But it describes that under certain types of circumstances, if you're incapacitated and you've got a terminal condition or an irreversible condition, or you're expected to die within a relatively short period of time. Maybe you've got you're brain dead and you're not, and the doctors have said, there's no hope of this person coming out of that. Then that's where that document would come into play. It basically just says, I want you to withhold any kind of medical treatment other than that needed to keep me comfortable and allow my body to just die naturally on its own.
Yeah.
That's basically the essence of that document.
So doctors love when people have this because, one, it takes the pressure off of them, because the scenario that you do not want to have happen is, like Jeff said, a person is brain dead. The doctors are saying there's no hope, and they find out that you don't have this directive to physicians. So now what they're faced with is they go out to the waiting area to inform the family of the sad news. And they say, what do you guys want to do? Hoping and praying that there's a consensus, right? Because they don't want to get in, have the person saying, hey, we'll see you in court if you try and do anything, doc. So what's going to happen is the room is probably going to divide into three groups. There's going to be the group that says, as sad as it is, pull the plug. It's time. Then there's going to be the group that says, no, doctors can be wrong. Miracles happen. Don't you pull the plug. And if you do, you'll be hearing from my lawyer. And then the biggest group will be in the back, staring out the window absent-mindedly. And they're going to be saying, I don't want to have any voice in this decision because I don't want it on my conscience.
Yeah.
I don't want to be the one to give the pull the plug on my loved one notification.
Sure.
So having this document, the person whose opinion matters the most in that moment is the person who's laying there and can't speak. It's their life.
Yeah.
This document speaks for them when they cannot speak. And what that does, one, it takes the pressure off your doctor, right? Doctor has the, hey, I did what my patient wanted. Two, the family, whichever your decision is, can at least rally around, hey, we respected the wishes of our loved one, and they don't have to live with any guilt.
It's peace of mind.
Yeah.
It's peace of mind for the family members, and it takes that burden off of them, off of their shoulders for having to make that decision.
Now we hear about the DNR, the do not resuscitate. Is that part of that directive to physicians?
No, see, now that's a very, very
separate
different
too.
document, and a lot of people do get that confused.
Okay.
A DNR basically is a do not resuscitate order, and the common one that that gets signed, if you're not in the hospital, is an out of hospital DNR, and it's a form promulgated by the state of Texas, and it basically says, if I am found without a pulse, then I do not want you to perform CPR. I don't want you to use a defibrillator. I don't want to be revived, for any reason whatsoever.
Yeah.
Right.
And that means, even if I'm, 45 years old and in reasonably good health, and I'm found without a pulse. I mean, and if it's only for 10 seconds or a minute, and if they revived me, I'd be perfectly fine and resume my normal life. They can't revive you if they know about it. So so for that reason, most people who are reasonably healthy and also middle-aged, even kind of somewhat older but not really, really old, most of the time do not get DNRs. It's usually not a document that most people need or want.
Okay. Good to know.
If you've got an end-stage kidney disease, end-stage heart disease, end-stage cancer, If you're 95 years old and you're just ready to, you feel like it's time, then certainly those documents can and should be considered for those people. There's also important considerations with regard to the location of the document, but I think Keith also wants to chime in on something.
Right.
Yeah. So we see this all the time. Whenever people come into our office, we say, bring all the legal documents you have. And frequently we will find in the middle of the pile a DNR from, so usually it's like several years ago and they just held on to it. And I've seen it enough. I usually know what's happened. At some point, they went in for surgery, and it could have been minor surgery on their elbow, right? Nothing life-threatening. And before they did the surgery, when you're signing all those papers at 5:30 in the morning and you haven't had breakfast,
Right.
one of them is a DNR, and that's for the protection of the doctors in the hospitals. They just sort of do it as a matter of course. And I understand the legal reasons why. But the people hang on to that. And because they think it's important and that they should. And I tell them, you shouldn't have an active DNR unless you are basically ready to go to heaven today. Because you could be, as Jeff said, you could be 45 years old, walking down the sidewalk, birds singing in the trees, whistling a tune, trip and hit your head and have a cerebral hematoma or something. And the ambulance drivers show up. And while it's true, I've never met anybody who walks around with a DNR in their shirt pocket, but just bear with me for the hypothetical.
Right.
Ambulance drivers show up and they're about to shock paddle you back to life. And they say, wait, what's that? And they pull it out. Oh, it's a DNR. Well, I guess we'll go get lunch, right? Now, I actually had the opportunity a few years ago to talk to a client who came in who had worked in high levels with EMS and that. And I said, now tell me the truth. What would really happen? And the answer I got was a little bit surprising. They said, the ambulance drivers, of course, have I don't know if they make them swear an oath, but I mean, their job is to do everything they can to get the person to the hospital alive and in a timely manner. And of course, they're going to do that unless there's a reason not to. So the answer I got was, under that scenario, if they saw the DNR, they would probably still transport to the hospital, do all the regular stuff. But if there happened to be a loved one nearby who was aware of the DNR and said, look, there's a reason my loved one is carrying this DNR. They've been battling stage 4 terminal, whatever, for a long time. And it's their wish that if their heart, like Jeff said, if their heart stops, that you not shock paddle them back to life so they can suffer more. If there's a person there advocating for that and with a good story and explaining, they will actually stand down. At least that's what I was told. So
okay. So I guess so it sounds like it's a rare occurrence, but as our parents get older, there might be some, because of what you mentioned, end stage diseases, where they may have choose to have one. So I guess the answer to that is that you do need to have an out of hospital DNR as well as one in the hospital, and you need to make sure that it's visible and everybody knows where it is.
Yeah, the visibility is crucial because if they the ambulance shows up or if you're at a doctor's office or where whatever, if you are somewhere and your heart stops and the medical personnel, whoever they are, paramedics or otherwise, if they are not aware of a DNR, then they're going to bring you back to life. They're because that's
their job.
Yeah. And so, it's absolutely critical to have that document with you at all times. So you'd carry it in your purse, carry it in your pocket, carry it. If it's important to you to not be revived, you're going to want to make sure, and you'll have it posted in your bedroom. Maybe you have it posted in your living room. You don't even have it if you're talking about at your house, having it in a desk drawer, not critical, not helpful at all because the paramedics aren't going to look in the desk drawer.
Yeah.
Jeff and I were talking last week actually with a client, and we were being somewhat funny about it, but we said, you could have a T-shirt made and copy the DNR on your T-shirt, or you could have a tattoo put on with a QR code or something, an arrow.
Scan here for DNR.
Scan here for DNR.
That's getting pretty intense, I guess.
Yeah, it is.
Okay.
Yeah.
Last question.
It's a little bit humorous, but it
Yeah.
drives home the point that
Because they have to be able to see
gotta
it.
know
because-
it.
Right. Yeah.
unless they know about it, they can't do it.
That's right.
Yeah.
I know that we sometimes hear like, "Hey, are these a HIPAA release or the medical directive? Is this just something I can go print off online and be able to get that filled out?" What are the risks for sort of DIYing
doing
it?
it yourself.
Yeah. So the risks of the do-it-yourself are pretty substantial. A person who doesn't know what they're doing doesn't know that they don't know what they're doing, right? And it's really easy with legal documents. I've had clients before say, well, look, I can read, and this is in English, and so I can tell what's in there. But the thing that you don't know is what's not in there. Like for a person who doesn't know car engines, you can pop open a car engine and you might be able to identify certain parts and everything. But if you're not an expert in it, you may not notice that, say, the Johnson rod is missing, right? And a real mechanic would know, hey, the Johnson rod, you can't run a car with that safely. But you don't know what's missing. And all these pre-printed forms and stuff, first of all, you have no idea who came up with the language in there. How do we even know that they know what they're doing, right? You're putting a lot of reliance upon that. So we always encourage people, go to an attorney who knows, and can say, yes, all these parts are there, all the parts are not there, and they can explain what they mean. Many times in these legal documents, you have to make choices.
Right.
And if you're just kind of, randomly throwing darts against the wall going, well, that sounds pretty good, you may not get the result that you want.
Yeah, these are important choices.
Right. And there was
There may be blanks in the document, and you may leave some of them empty, thinking that that's okay. But in fact, those blanks really need to be filled in. So it's always good to get advice from an attorney on these kinds of things, because an attorney has special training, just like a dentist has special training, or an automotive.
I always think about the scene in
Mechanic.
the Tom Hanks movie. What was it with the soccer ball? I'm losing
Big?
it.
No,
The one he's
Castaway.
Thank you. He's
Castaway.
lost on the island.
Yeah.
And he has the tooth he has to get out. He takes the ice skate and he knocks the tooth
right.
out with a rock and an ice skate.
Pulls his own
And
tooth.
technically it worked, but I mean, we're in 2023 and you have access to
Right.
a lot better dental care than that.
Right.
So,
Good comparison.
And
Yeah.
just one quick thing that I thought of is just to make sure, since you're Texas attorneys, most of this language is going to be similar. It may just, or the documents that you need are going to be similar, whatever state you're in. There may be some different language.
Yeah, absolutely. It's important to use the form or to consult with an attorney, with the specific language that's important for your particular state. So you wouldn't want to use a Texas form if you were in Maryland, if you were living in Maryland, or now. I say this, but I mean the forms are valid across state lines, because all contracts and legal documents are valid across state lines. So if you're visiting Maryland, you don't need to go get a new
Right.
new medical power of attorney for up there. But you do generally want to use the form or use the language for the state you're in, and you bring home the good point. It's the gist of the document is going to be the same across all states. The language used, though, is going to be a little bit different and maybe interpreted slightly differently, just depending upon each particular state. And each form or each state may have its own particular small nuances within the form or within their normal. Yeah.
When people come in and they're signing their legal documents, including the medical power of attorney and the others, one of the last things that I tell them before they leave is that, hey, be aware. To this day, I've never met, and myself included on this, anybody who goes on vacation and while they're packing their swim trunks, and their flip flops to go to the beach, they go, oh, I better go pack my medical power of attorney in case there's some type of an accident, right, or an illness. I tell them that, at least in our case, and I know a lot of law firms do this, we do keep a scanned signed copy on our computers. And so if there were an incident and you were away from home and your loved ones are going, oh, we need that medical power of attorney if it's back home in the bedroom closet,
Right.
they can call our office for our clients. And, just with a couple clicks of a button, it's already electronically scanned. We can send it anywhere in the world that they need. So,
Yeah.
Good to know.
That's great.
Good to know.
And
A
the
lot of-
client can also ask for a scanned copy as well, and we can
Yeah,
provide that. And of course, we always give paper copies to the clients as well, and they can give them to their loved ones. And the loved one, if it's on a Saturday and our office is closed, the loved one can scan their own copy and send it to. So it's good to share.
Yeah, there's just a lot to you got to take care of.
Yeah, good to know. Jeff Barnett, Keith Ludy, thanks so much as always for clearing things up.
Yeah, you bet.
Our pleasure.
Mm-hmm. I think what it does is it just teaches us we need to be prepared. Mm-hmm. We have to have everything possible, all these documents, just in case, whether it's for mom and dad, for us.
Sure,
whomever.
Yeah, important for us too. And the earlier you do these, hopefully, probably the easier it'll be.
That's right. Hey, if you have any other topics you'd like us to discuss, please let us know. Parenting aging parents.